Hi, my name is James Rickman. I'm a student attorney at the UIC Fair Housing Clinic. Recently, the Illinois eviction moratorium ended on October 3rd. Right now, around 60,000 people are facing eviction because of this. So today, I'm here to talk about the eviction process in Illinois, reasons a tenant can or cannot be evicted, an overview of what the process looks like, and the things that landlords are prohibited from doing. We also talk about discrimination in housing and how that is manifested during the pandemic, and some common defenses to evictions. Please enjoy.
Before we begin, I have to provide a disclaimer. I'm a law student and not a licensed attorney. The information contained in this presentation today is not legal advice. If you have any questions regarding this information as it pertains to you, you should consult with a licensed attorney. The information in this presentation only applies to those who are facing eviction after the moratorium has ended. It does not cover any information if an eviction was filed against you during the moratorium. First, we're going to start off with valid reasons a landlord can evict a tenant. Valid reasons include failure to pay rent, violation of the lease agreement, damage to the property, and not vacating the property after the lease has ended. There are, however, reasons that a landlord cannot evict a tenant. These include a tenant complaining to the landlord about their unit or building, non-payment of rent because the tenant left the property for reasons related to a domestic violence situation, and, most importantly, which the UIC Fair Housing Clinic handles, is that a landlord cannot evict a tenant because of that tenant belonging to a protected class. In Illinois, there are 14 protected classes. These protected classes include race, color, national origin, ancestry, sex, disability, religion, familial status, unfavorable discharge from the military, military status, age, marital status, sexual orientation, and being a protected party under an order of protection. While we have made great strides in the United States, housing discrimination is still a large problem, and discrimination against certain groups in housing has become worse due to the COVID-19 pandemic. In 2020 alone, there were over 28,000 housing discrimination complaints. Unfortunately, the number of housing discrimination claims has remained consistent over the past few years. However, there has been a notable rise in discrimination and harassment among Asian Americans and Pacific Islanders. According to the National Fair Housing Alliance, they saw a 9% rise in discrimination and harassment against these groups. They also found a 40% increase in complaints related to discrimination based on sex and disability. Even more unfortunate is that the Midwest is the second worst in the number of housing discrimination complaints, with over 5,000 complaints. Now, we are going to go over what the eviction process looks like generally in Illinois. We will start with an overview of the legally required notice that a landlord must give before starting eviction proceedings. The first type of notice that we will discuss is a 5-day notice. This notice is given for non-payment of rent. This notice must be in writing and must include the date, the address of the building or unit, when the lease will end, the amount due for rent, and state that the tenant has 5 days to pay the rent. If the rent is paid back within the 5-day period, the landlord must accept it. If the money is not paid back, then the landlord can start eviction proceedings. The next type of notice we're going to discuss is the 10-day notice. This notice is served for violation of the lease agreement. It's important to note this does not cover illegal activity. Much like the 5-day notice, this notice must also be in writing, contain the same basic information as the 5-day notice, and state the rule in the lease that was violated. However, if you fix the lease violation within the 10-day period, then you will not be evicted. For example, there's a provision in a lease agreement that stipulates that no personal items can be left in the common areas, and the tenant leaves their belongings in the common area. Upon service of the 10-day notice, the tenant would have 10 days to remove their belongings from the common area. If they remove them within that period, they will not be evicted. However, if they fail to do so, the landlord can start eviction proceedings after the 10-day period. The last type of notice we're going to discuss is the 30-day notice. This notice is used for month-to-month leases and when the landlord does not intend to renew the lease. These notices, much like the 5 and 10-day ones, must also be in writing. This last type of notice is also dependent on your location. Specifically in Chicago, landlords that want to terminate your lease must give you 60 days notice if you've been living in your apartment for more than 6 months but less than 3 years. If you've been living in your apartment for more than 3 years, then the landlord must give you 120 days of notice. If these notices are not heeded, then a complaint will be filed in the appropriate circuit court. If the resulting case ends in judgment in favor of the landlord, then an eviction order will be entered, and the tenant will receive notice that they must move out within a certain time period. If the tenant does not move out within this time period, then the tenant can be forcibly evicted by the sheriff. Next, we're going to talk about eviction for public housing, which has different requirements than renting from a landlord. Like the regular eviction process, the landlord in charge of public housing must give the tenant written notice before evicting them and describe in detail the reason. Furthermore, they must state whether or not the tenant has a right to a grievance hearing. Notice can be given to the resident directly, to a person who lives at the tenant's home that is 13 years or older, or through certified mail. For public housing, there are two types of notice: the 14-day notice and the 10-day notice. The 14-day notice is served when the tenant has not paid the rent. The 10-day notice is served for violent or drug-related activity or behavior that threatens others. Common reasons of the tenants not having the right to a grievance hearing are that the tenant does not request a hearing on time, the eviction involves activity that threatens the health or safety of others, the eviction involves violent or drug-related activity, or any activity involving a felony conviction. Now, we are going to discuss some common defenses to eviction. While there are many defenses to eviction, we are only going to cover some that are most common. Probably the most basic defense stems from the notice requirements that we discussed earlier. This could be, for example, the notice not having the required information, or the eviction case was filed against you before the time on the eviction notice expired. Another common defense deals with the issue of rent. For example, you do not owe the amount of money your landlord claims that you owe, you've paid all the rent money in the required time, or you've withheld rent because the landlord refused to make necessary repairs after being given notice by the tenant that they were needed. Again, there are many defenses to eviction, but these are the most common defenses. If you find yourself in this situation, you should seek legal advice from a licensed attorney. Now that we have gone over a basic overview of the eviction process and some of the legal requirements that are attached to it, now we will discuss some things that a landlord cannot do in order to remove you from your unit. These are called self-help evictions. These include lockouts, removing your belongings, blocking the entrance to your unit, or shutting off your utilities. These are all illegal acts and you may be able to recover damages. If your landlord has done any of these, consult with a licensed attorney. Fortunately, there are multiple legal aid organizations to help in these situations. If you believe that you are under threat of eviction due to discriminatory housing practices or the victim of discriminatory housing practices, do not hesitate to contact the UIC Fair Housing Clinic. The link to our website will be posted in the description below. If you believe that you're under threat of eviction and need legal counsel, there are plenty of legal services in the Chicago area. Some of these include the Lawyers Committee for Better Housing, Carpels, Legal Aid Chicago, and the Metropolitan Tenants Organization. The links for these organizations can be found down in the description.
To recap, today we've gone over the basic eviction process in Illinois, reasons a tenant can or cannot be evicted, defenses to eviction, and actions that a landlord is prohibited from taking. And just a reminder that all resources mentioned in the video today, their links will be down in the description below. Thank you for watching.